Welcome to the second in our series of webinars focusing on rural disputes. My name is Stephanie Hepburn and I'm an associate in our property disputes team. I have particular experience in contentious property disputes and I have an experience in the Sheriff Courts, Court of Session, as well as the Land Court and Lands Tribunal. With me is my colleague Elaine Brailsford, who is a partner in our commercial and property disputes team, who has a wealth of experience in all contentious property matters. Hello. In today's webinar, we are going to look at debt in the countryside and explore the various methods of enforcement, focusing particularly on attachment of livestock and the key issues that arise from this and what this means for landowners, tenants and their advisors. We do hope to have 5 minutes at the end of the webinar to answer any questions you might have, so please use the chat facility on your screen there to type in your questions, and if we have time, we'll pick up one or two at the end. So Elaine, to start us off, let's talk a wee bit about debt in the countryside generally and your experience of this.
Well, we are regularly instructed by both rural landlords and tenants in relation to all matters debt related, but this is often a landlord wanting to pursue an agricultural tenant for rent arrears, or it could be tenants wanting to defend action taken against them, either for rent arrears or other lease obligations, or supplier debt.
And what do you think are the challenges in relation to the recovery of debt in the countryside?
Recovery of debt is not always as straightforward as it seems. There are a number of different options for recovery that landlords may in fact not be fully aware of. Similarly, tenants are not always aware of the options that they have for stopping enforcement if they consider it's wrongful enforcement of debt. Success for either party usually means acting promptly and assessing the prospects of successful recovery, or whether there's a defence, and those considerations should really be made at the very start of the process. In the rural situation, you may be talking about an agricultural situation where there may well be little cash at hand. Indeed, that may be the reason for there being a debt. You know that old adage, you can't get blood out of a stone. So the first thing you need to do if you're the creditor is to assess whether you are dealing with a stone. Second point is how quickly can you move, since the creditor wants to get himself first in the queue for any funds or assets that may be available. From the debtor's perspective, he needs to be aware that matters can move rapidly. And so if there's a genuine dispute over the debt, he needs to engage promptly about that. He might be in a position to take urgent steps to stop any wrongful enforcement, for example.
Okay, so if you are the creditor then, how do you get yourself first or even ahead of that queue to make sure you can get your debt recovered?
What we call summary diligence is really the key to moving quickly. In broad terms, summary diligence is the enforcement of an obligation without the need to go to court. A document of debt is needed, and that is a deed in which parties have agreed to the registration of that deed for execution in the books of council and session. It's often a lease or a minute of agreement, or it could be a guarantee. The debt requires to be identifiable from the terms of the deed. So in a lease, it would be the contractual obligation to pay rent that's not been paid, and that would be the debt that you would be enforcing. Once the lease or minute of agreement has been signed, if it contains a clause allowing for registration, it gives whoever has the principal lease the right to send it off to the books of council and session for registration. This is usually done as a matter of course once the lease or document has been signed, but there may be tactical or other reasons for not registering it straight away. For instance, if a party doesn't want the document to be registered on what is in fact a public record, so all the terms of that document would be available to the public, or where they suspect the other side may wish to commence summary diligence against them, they may prefer that the creditor of the obligation holds on to it without registration.
So in theory then, you could not register the lease at the time it's signed, and if you're the landlord, only do so at the point you wish to recover a debt in the future without having to go to court.
Yes, but remember, it's only the person who has the principal lease who can send it off for registration. So that's something worth bearing in mind.
Okay, so when the lease or other document has been registered in the Boots Council in session, either at the point of signing or at some other point in the future, this gives you the right to start a summary diligence, which essentially is enforcing the obligation contained in the lease or other document without having to go to court. Is that right?
Yes. What parties don't often realise is that the effect of such a clause, which allows registration, gives that deed the same effect as a court decree, and that is because the extract of the deed will contain a warrant by the Lords of Council in session for all lawful execution, and therefore that is essentially the same as a court decree. So in practice, you skip the whole court process and you're in a position to take steps to recover the debt just as soon as you have your extract registered deed. That, in essence, is summary diligence. It's great for the creditor, but for the debtor, the ability to challenge the right to enforcement has been missed.
Are these clauses standard?
Such a clause is often found in commercial leases, but there's no reason why it should not be in a rural or an agricultural lease. In fact, I think it may be standard to have a clause agreeing to registration for execution. Although, as I've said, parties perhaps do not understand the full effect of having such a clause in their lease.
And what if your lease or other document doesn't have this registration clause in it?
Well, you wouldn't be able to do summary diligence, and you would need to raise a court action in the usual way. So you would raise your action, the debtor defender has an opportunity to lodge defences, and if it's defended, it goes through the whole defended court process. However, at the end of the day, if your court action is successful, you will have a court decree which you could then enforce.
So once you've decided that you want to enforce a debt by way of summary diligence, or you've gone through this whole court process and you've got a court decree in your favour and you want to enforce that, what are the methods of enforcement that are available to you?
There are a range of enforcement options, and that's whether you're proceeding by way of summary diligence or court order, they're the same. There is inhibition, which you register on the property register, and that prevents the voluntary dealing of heritable property. There is arrestment, which seizes goods held by third parties, but that shouldn't be confused with attachment. Arrestment is where the goods are not in the hands of your debtor, but in the hands of a third party. Bank arrestments, that's self-explanatory, it's the bank account you would be arresting. Earnings arrestments, and then there is attachment of goods.
And are all these forms of diligence often used in the rural sector?
Some may be considered to be of limited use. Earnings attachment is obviously only of use when there's an employer, not where you may have a tenant farmer operating on his own account. Similarly, bank arrestment will probably be useless, because if the debtor had cash available, you might think that he would be better using it to pay his debt. Attachment is the one method of enforcement which is most likely to be the most effective in the rural sector, but it's often the method people know least about.
And today we're going to look more at enforcement as a method of attachment of goods. What is attachment then?
Attachment is the seizing of goods belonging to the debtor with a view to their ultimate sale to satisfy the debt. It requires there to be a charge for payment served first before the attachment can take place.
And what is a charge for payment, and who would serve that?
A charge for payment is a formal demand for payment, and it will be served by sheriff officers or messengers at arms. The charge gives the debtor 14 days to make payment, If payment isn't made within the 14 days, then you can proceed to carry out the attachment. The charge for payment lasts for 2 years, which means that you can carry out the attachment at any point within 2 years from from the expiry of the 14 days. You do need, if it's an individual debtor, to serve a debtor advice and information pack along with the charge for payment. This pack lasts 12 weeks, so if the attachment is to take place after the expiry of 12 weeks, but within the 2-year period, a new pack would have to be issued.
And what goods can be attached?
You can attach items such as tractors, other farm machinery, quad bikes, items in the farm office, and livestock. There are a number of items that cannot be attached. You cannot attach a vehicle that is reasonably required by the debtor worth up to £1,000. You cannot attach items within a dwelling house unless you have what is called an exceptional attachment order, and that requires to be granted by the court. There is also protection for tools of the trade, but only to the extent that these are worth up to £1,000. And you cannot attach a mobile home, which is the debtor's only or principal residence. You also cannot attach cash.
So, when you say you can attach livestock, are you talking about attaching cows and sheep?
Yes, I am. Yes, there are a number of considerations that must be taken first, though. For instance, attachment of livestock, and particularly if it's subsequently sold, may have the consequence of ending the farming enterprise, not something perhaps wished for by either landlord or tenant. However, I do have experience of attaching livestock and farming equipment, and it can be a very effective tool for a landlord or other creditor. From the tenant or the debtor's perspective, it's something that they will wish to avoid at all cost. It could, for instance, destroy their farming enterprise.
Before we look at attachment of livestock and machinery in more detail, what if you're a tenant? This is quite a serious thing to have happen to you. How do you stop what might be wrongful enforcement?
Well, what you would have to do if you were in that situation is go to court and seek an order of suspension and interdict. So again, speed is of the essence here. The object of suspension is to stop the enforcement action until the rights of the parties can be fully determined. So, you know, there's no point in proceeding if the diligence has already been fulfilled effectively. And like any interdict situation, the creditor can lodge a caveat in court in order to be notified of any application for suspension and interim interdict before it is granted. So that would give him an opportunity to be heard at any hearing.
At what stage would the debtor raise these proceedings?
Well, as I've said, really at the earliest opportunity, when he's aware of steps being taken to undertake diligence, because preventing the diligence will be defeated if it has, as I've said, already been executed. It's worth noting, however, that whether, in considering whether an order should be made, the court may order cation or consignation. So cation is putting funds up or security for the debt. Consignation, similarly, is putting funds into court to cover the level of the debt. And that's there for security for the creditor, because if the challenge is ultimately unsuccessful, then the creditor really should not be prejudiced by that. Obviously, to successfully suspend the diligence, there requires to be a case made out that it is wrongful. It's not good enough simply to say this action is going to destroy my livelihood.
So that's quite a lot for a tenant or a debtor to consider before raising an action for suspension and interdict then. Assuming there's not any such action or an action isn't successful, I guess there'll be a number of challenges that may be faced if a creditor is attempting to attach livestock and machinery. Before you tell us about these challenges, can you tell us a bit more about the attachment of goods and equipment generally, and how you go about this?
Well, the whole process, attachment of goods, is governed by statute, the Debt Arrangement and Attachment Scotland Act 2002. So once you've served your charge for payment, and once the days of charge have expired, and you'll remember I said that was 14 days, and there's been no payment forthcoming, you would instruct sheriff officers to go out and attach the goods belonging to the debtor.
And when you say attachment, do they actually physically take away the attached goods?
At that stage, no. Attachment is legal rather than physical at this stage. An inventory of attached goods is prepared and a value attributed to them. Sheriff officer will attach sufficient goods to cover the amount of the debt. They'll then prepare a report on the attachment and report to the sheriff within 14 days. The debtor is entitled to redeem the goods attached within those 14 days by paying the value attributed to them by the sheriff officer, which is why the creditor cannot sell these goods within that 14-day period. The effect of the attachment is that the goods cannot be disposed of by the debtor either, so if the debtor does that, that would be a contempt of court. It's also worth noting that attachment can only take place between 8 AM and 8 PM and not on Sundays or public holidays. So you should check with sheriff officers whether it's feasible to complete the attachment within this period.
And would attachment of farm machinery take place using the method you just described?
Yes, attachment of farm machinery is relatively straightforward, providing the value is in excess of the statutory £1,000 tools of the trade limit. Such machinery may be valuable, but it may also be subject to hire purchase agreement or retention of title, and that would prevent attachment. Sheriff officer must make reasonable inquiry about ownership, and they will in fact carry out hire purchase checks. It's for the owner of the equipment to prove to the sheriff officer that they hold title to the equipment. But if they produce satisfactory evidence that the item belongs to them, then it should be released for the attachment.
Moving on to the attachment of livestock and your experience of that. You mentioned you'd been involved in a case where you attached livestock. Can you tell us a bit about that?
We had a situation where a tenant farmer was seriously in arrears with his rent. The only asset that we thought we could attach were his sheep and cattle and some vehicles and machinery. From memory, I think he had something like 1,900 sheep and he had several cattle. Yeah, a number of challenges arose in that case.
I can imagine. Let's look at some of these challenges then. I'm guessing one of the main hurdles is actually identifying the stock and ensuring that it belongs to the debtor.
Yes, obviously only livestock belonging to the debtor can be attached. The actual attachment requires all the stock to be identified, valued and inventoried. This required, in our case, the assistance of shepherds and also a valuer to assist the sheriff officer who undertakes the attachment. The identification bit was a challenge. All tags had to be recorded, which meant, of course, that the sheep had to be herded into batches so as to ensure individual tags were correctly recorded, that we didn't double count or double record any, or indeed miss any.
What about the cattle?
We didn't, in fact, attach the cattle. In order to sell the cattle, we would have needed their passports, and although those may well have been in the farmhouse, we could not, of course, carry out attachment in a dwelling house because we hadn't got an exceptional attachment order. Also, I doubt passports would have been regarded as legitimate subjects for attachment. What might have been required was an order from the court ordaining the farmer to deliver over the passports, but I think a farmer could well argue that there's no obligation on him to deliver up anything as part of this process. So I doubt such an action, had we tried that, would have been successful. So in the end, we didn't proceed to attach the cattle.
So once you've done the attachment side of things, will there be an auction immediately after the attachment takes place to sell the livestock?
Not immediately, no. Once the livestock and indeed any equipment are successfully attached, there is, as I've said, 14 days during which the debtor is entitled to redeem the goods. This does cause a problem because it means you can't immediately uplift the goods or livestock, and of course there's a vulnerability there, even although the debtor is prohibited from removing the goods during that period.
And what if, once the attachment has taken place in this 14-day period, the debtor simply runs off overnight with all these animals?
Well, it might be a bit difficult with 1,900 sheep, but I think if the debtor does that, then he is in contempt of court. If you are concerned there's a risk the debtor may do this, or he's run off with some but not all, and you want to protect the remaining goods or livestock, that might be grounds for seeking an immediate uplift. Sheriff officers do have power to remove an attached article without notice if they consider it necessary for security or preservation of value and there's insufficient time to go to court. But otherwise, you would have to get an order from the court to uplift during that period, and it would have to be on the basis of security. Indeed, in the case that I've been talking about, we did actually go to court to get such an order because one of the vehicles vanished from the farm overnight.
And how is the auction arranged?
The auction has to be advertised, and the debtor must be given notice of the date on which the auction is to be held and also the location. The timing of the notice and the auction can be tricky. Certain livestock sales, as you probably know, are only at certain times of the year, and it can be a challenge to ensure that you're able to time everything to make the appropriate sale. Key message here is seek advice.
And where will the auction be held? Is it held on the farm?
The 2002 Act provides the auction must be a public auction held in an auction room, unless this is impractical, in which case you can hold it elsewhere. In the case of livestock, the appropriate location may be the local livestock mart.
And was that where the auction in your case was held?
Yes, it was, although we did consider holding the auction on the farm, but the auctioneer felt that we couldn't do that because there was only one pen, and for the sale to take place, the sheep needed to be put into groups and numerous pens. The auctioneer was also concerned that because it was a remote location, no one would attend the auction, and therefore we wouldn't successfully sell the attached goods.
So if you are going to move the animals to a livestock mart, if it's felt it's not appropriate or practical to have the auction at the farm, what about animal movement requirements?
Yes, indeed. It's necessary to liaise with the Scottish Animal Movement Unit, and the sheriff officers should ensure that there is a movement licence completed which travels with the animals to their ultimate destination. It's also necessary to ensure that where the livestock is to be held and auctioned, that that place is registered with the Animal Plant Health Agency.
Which a livestock mart would be, yeah.
Yes.
And who's responsible for the welfare of the livestock in this period between attachment and the auction and ultimate sale?
Once the livestock is removed from the farm, the responsibility is on the creditor. So in our case, we contracted with the mart to look after the animals once they were delivered. You'll recall I mentioned that we had got a court order to uplift them almost immediately for security purposes. So we then had to have somewhere for them to be housed, and the local mart looked after them, and we were charged, the creditor was charged for that and also for their feed.
And then what happens after the auction takes place?
The sheriff officer does a full report, and that is sent to the sheriff, and if the sheriff approves it, the funds realised are released to meet the debt and associated expenses, and any surplus is returned to the debtor. Unsold items pass to the creditor, and will be deemed to have been acquired for the valuation placed on the articles in the valuation. Debtor is entitled to bid for his own livestock at the auction.
And in your case, despite all these challenges that you've told us about, the attachment was successful?
Yes, it was successful. It was very successful. Notwithstanding that it's a complex process, livestock may be successfully sold at auction. There is, as I've said, a window of opportunity for livestock sales, and thus timing is essential. In our case, there was also a consideration of when we did the attachment due to weather conditions, and that all had to be lined up with the appropriate sale that we were aiming to put the livestock into. The value placed on the livestock by the valuer sheriff officer is usually conservative, and so if sufficient animals can be attached and sold, then the sale price usually will cover the debt and the expenses of the exercise. So in the case I was involved in, it was a worthwhile exercise for the landlord, who did indeed cover his costs and recover the debt. For the tenant debtor, I'm sure it was a devastating experience. He was left with little livestock, and in fact, ultimately, the tenancy was given up.
I guess that's something that landlords might want to take into account when going down this route, is ultimately it might end the tenancy, which might not be what they want.
Exactly, because that may end the stream of income which you might be able to get going forward, although clearly the landlord has to consider, if there is a debt, what's the likelihood of the tenant being able to maintain his obligations going forward.
Yeah. Thanks, Elaine. There's obviously quite a lot to think about here for both a landlord and a tenant. I think for both, from what you've said, there's no point in not facing up to a debt situation at the earliest opportunity, and a satisfactory resolution without enforcement must be the preferred route. That concludes our webinar on debt in the countryside and the attachment of farm machinery and livestock. We do have a couple of minutes for questions, if anyone has any. Don't all jump at once. Our contact details are on the slide there. So if anyone has any questions at a later date, please feel free to get in touch, or indeed if you discuss any current cases you might have or any similar experiences, happy to share with us. Anything to add, Elaine? Is that?
No, I hope that was helpful. It is a complex area, and so if you do have any particular questions, I'm more than happy to pick them up offline.
Thank you.
Thank you.